This is a fantastic response. It really does go in very respectfully, but spicily, calling out the lies, the false narrative spinning that Blake Lively is doing here. So what is this thing you don't have? She keeps, the evidence.
The sound of the gavel echoed through the courtroom as the judge ordered Blake Lively's deposition sealed, wiped from public access in a single ruling. Almost immediately, the mystery began fueling speculation. Why was it hidden? What testimony could be so sensitive, so potentially destructive, that it had to disappear from the record? Attorneys familiar with the proceedings say the decision could mark a crucial victory for Lively, shielding her from a wave of damaging headlines. But others see it differently. They warn that sealing such testimony often suggests the material inside carries serious weight, evidence that could alter the course of the entire case if it ever came to light. This unexpected move leaves the public with more questions than answers. Is this a protective measure, or a warning sign that something far bigger is being kept under wraps?
Along with the letter, Fritz submitted the transcript of the deposition. However, it was sealed to the public in accordance with Lively's protective order. Now, there's a question of should they have the whole filing, whatever, but apparently they can, and they did, and she has every right to then, seal it. It was sealed in the public accordance with Lively's protective order and asked that the court not rule on the seal for a week so that the parties can meet and confer, and Miss Lively may file a motion for continued sealing if she so chooses. Now, this then prompted a bunch of PR, seemingly from Blake's side. Oh, look, he's shaming us. He's putting this out there. How dare they? This is this is about a media campaign. Meanwhile, it's Blake who's clearly speaking to the media and painting this as a victim of Justin's actions, which this is all just legal actions that they're allowed to do. But this was the press wave that then went and people...
The moment the gavel struck, the atmosphere shifted. Blake Lively's deposition was sealed in an instant, wiped from the public record as if it never existed. The silence that followed was almost eerie. Reporters froze mid-keystroke, sketch artists' pencils hovered in the air, and the steady hum of the ventilation system became the only sound cutting through the stillness. What had been expected to unfold as a routine scheduling session suddenly transformed into one of the most consequential turning points of the case. The scene itself carried an unusual tension. On one side of the courtroom sat rows of seasoned attorneys in tailored suits. On the other, members of the press and carefully placed spectators who had waited days for something sensational to surface. When the judge issued the sealing order without hesitation, cameras faltered mid-click, and the gallery traded confused glances. Questions rippled silently through the room. Was this about protecting personal security, safeguarding classified evidence, or shielding the reputation of one of Hollywood's most scrutinized stars? No explanation was offered, and if one existed, it never made it to the record. Sealing testimony in high-profile cases is not unheard of. Actors squaring off with studios, musicians locked in contract wars, but the speed of this ruling stood out. Similar moments have occurred in other blockbuster trials, where depositions vanished overnight, but rarely with such immediacy. One moment Blake sat upright at the defense table, shoulders tense and palms pressed firmly against the wood. The next, she leaned toward her attorney, whispered a few clipped words, then fixed her gaze forward, holding it steady for nearly 10 seconds after the judge's command. For seasoned observers, that restrained reaction spoke volumes. Legal analysts later remarked on the unusual decisiveness of the move. There was no recess, no pause to review the paperwork, just a direct ruling that came right on the heels of a fiery exchange between both legal teams earlier in the morning. What unfolded in that rapid-fire debate remains unknown, but it was persuasive enough to prompt the judge into action without delay. That moment not only escalated the stakes but signaled that the real fight in this courtroom was only just beginning.
Unclear, here it is, why Miss Lively refers to her deposition transcript as a rough draft, given that the document is not marked as rough, as such versions of transcripts traditionally are. So he's making it clear, this is not a draft. This means Lively's statements are true. These are accurate transcripts. That's what they submitted. Let's continue. Miss Lively frames her argument as a motion to strike pursuant to Federal Rule of Civil Procedure 12.5 in the court's inherent power. However, Rule 12 does not authorize this court to strike documents other than pleadings. And then look what they do. They're quoting Lyman cases. Judge Lyman cases is what they're doing. Pleadings including only the complaint answer to cross claims and counterclaims. They do not include exhibits submitted in connection with oppositions to motions. And then there's another Lyman case. He points out to Lively that their filed motions under strike only allow the court to strike documents that constitute pleadings. It doesn't allow to strike attachments. He then cites two of Lyman's own cases as authority on this point, which is just brilliant. When you can do that, you absolutely do that to remind the judge, you know this is what...
This wasn't a routine protective order, it was a deliberate legal strike, executed with precision by Blake Lively's attorneys after weeks of quiet preparation. Behind the scenes, they had filed strategic motions, crafted airtight arguments, and built momentum for a single purpose: to ensure her sworn testimony never saw the light of day. By the time they entered the courtroom, their playbook was already set in motion. Their central argument hinged on the legal concept of irreparable harm, a phrase that carries heavy weight in high-stakes litigation. They insisted that releasing Blake's words would cause damage beyond repair, not just to her personal reputation, but to ongoing business interests tied directly to her public image. They warned the court that if the deposition leaked, the fallout wouldn't end with this trial. The consequences would stretch far beyond the courtroom, dragging uninvolved third parties into the fray and compounding the risks. The opposition didn't stay quiet. They pushed back hard, insisting on transparency and noting that Blake herself had previously spoken about related matters in public interviews. Their argument was clear: once a celebrity addresses an issue openly, it becomes fair game in legal scrutiny. The tension built quickly, turning the hearing into a live clash between the principles of privacy and accountability. Then came the turning point. Blake's team executed a rarely used but powerful tactic: an emergency motion filed before the hearing even began. That maneuver forced the judge to rule before the deposition could officially be entered into record. Timing was everything. By moving first, they left no opening for leaks, no chance for the press to get even a glimpse. Hollywood has seen echoes of this strategy before. A famous actor's rehab testimony sealed away without warning. A chart-topping singer's financial disclosures erased overnight. In each instance, secrecy itself became the headline. Blake's attorneys leaned into that pattern, citing specific court rules and painting her testimony as not only irrelevant but dangerously prejudicial, full of speculation and narrative spin that could taint the case. Their framing put the judge in a corner: either protect the record or risk releasing statements that might later be deemed inadmissible. The ruling came swiftly, underscoring how persuasive their case had been. Yet skepticism lingered. Court watchers noted that earlier filings suggested her deposition went straight to the heart of the allegations, making its sudden disappearance feel unsettlingly convenient. Still, in this round, the outcome was undeniable. Blake Lively's legal team secured a decisive victory, while the public was left with a gnawing question: what exactly was sealed away behind those closed files?
Argues in the blue section here that because of her gratuitous letter to the court, which was further an argument on our opposition to motion, which was disguised as a motion to strike, Lively invited Wayfair to respond with evidence in the transcript attached. Basically saying here, obviously, hey, you opened up this can of worms. The Wayfair parties responded citing Miss Lively's deposition transcript, which was attached as an exhibit, to demonstrate for the court that Lively's allegations of an ongoing smear campaign are unsubstantiated. By improperly submitting additional argument on the motion to quash, Miss Lively invited a response that would include evidence to establish the true reason why Miss Lively served the subpoena upon Liner Friedman. It is routine for the court to consider deposition testimony in connection with discovery disputes. And again, look, they're just citing another Lyman case using deposition testimony. Miss Lively's contention that the Wayfair parties did not hope to make her defend to continue sealing of the transcript so they can advance a false narrative that she's afraid of her deposition testimony becoming public. Miss Lively will either move to permanently seal her transcript or she will not. The choice is her. Where is there proof of this evidence of them saying she's afraid to? They're making it clear that it's odd she would seal her own testimony, but they have not said she's afraid of it anywhere. She's put that narrative out there. Now, Fritz then addresses the allegations that detailed deposition were leaked to the media. This part is crucial. Miss Lively next alleges that it also appears that the Wayfair defendants immediately leaked details from her deposition to the tabloid media. She does not cite any evidence. This is not surprising, as there is none. Miss Lively also fails to explain why any such leak could not have originated from Miss Lively, her husband, her multiple attorneys, legal or administrative staff from the law firm representing her, whose office she demanded host the deposition, or the catering staff employed thereby who served lunch. Putting aside the identity of the culprit, the identities of those in attendance for her deposition are not newsworthy because all parties are entitled to attend all depositions. For the reasons set forth, the motion should be denied. This is a fantastic response. It really does go in very respectfully but spicily, calling out the lies, the false narrative spinning that Blake Lively.
When a judge moves to seal testimony, it almost always signals that what's hidden carries weight far heavier than expected. In Hollywood, depositions rarely stick to dry, legal exchanges. They often peel back the polished surface, exposing contradictions in carefully curated public personas. For someone like Blake Lively, even a single misstep under oath, a casual remark or unguarded admission, could reshape headlines within hours. So when her testimony vanished from the record, speculation ignited immediately. Some insiders suggested the sealed transcript touched on her private family life, details never shared in glossy magazine spreads, stories that could have pulled loved ones unwillingly into the spotlight. Others whispered about business conflicts, confidential deals, or financial disputes that could tarnish her carefully protected A-list image. Then came the rumors of sensitive messages, texts or emails that may not have been central to the lawsuit but could still be used once placed under oath. A digital trail like that has the power to fuel scandals stretching far beyond a courtroom's walls. For that reason, observers believe the decision wasn't just about protecting Blake herself. Shielding the deposition might also have been a way to safeguard other influential figures, producers, investors, even celebrities whose names could have surfaced during questioning. Hollywood has seen this playbook before. Testimonies quietly sealed to preserve reputations, prevent collateral damage, and buy time. Yet history shows those barriers aren't always permanent. In one music industry feud, a sealed deposition resurfaced years later, sparking a new PR crisis. In another case, testimony leaked from inside the process, igniting lawsuits that dragged on for years. From what's known, Blake's deposition was anything but brief. Sources say questioning stretched for hours, attorneys rifling through thick binders while she sat at the table, her answers prompting loaded glances from opposing counsel. The transcript reportedly recorded frequent interruptions, objections cutting her off mid-sentence, forcing heated exchanges before questioning could continue. Legal insiders believe those objections weren't about small technicalities, but deliberate attempts to block entire lines of inquiry from advancing. If true, that means the sealed record could contain material extending far beyond the immediate case, potentially pulling in powerful names and exposing private dynamics across the industry. When the ruling slammed the door shut on all of it, the response outside the courthouse was immediate. Frustration, confusion, and a rush of speculation filled the vacuum left behind, with everyone wondering what secrets might now be locked away in the pages the public will never see.
She purposely subjected to this harassment during filming, so then, in fact, set forth in these allegations instances her detailed amended complaint. For good measure, it is undisputed that Miss Lively has seen the footage because she edited it. I love that as well. Not only were you there in real life so you know what happened, you edited the movie. You took over the movie with your editors and filmed it all. So what is this thing you don't have? She keeps, the evidence. She has no evidence, and she knows it. As for Jones's party, again, unclear what the relevance of the film footage is to their claims of breaches of contract concerning public relations and their defenses. This is what's so frustrating about Blake Lively's supporters. Yet again, proof of them gaming the system, manipulating the system, lying, and not being honest at all. But we're supposed to believe them and not Justin, who has actually given it all. And she's already had the footage, and she was there. But now it's Justin's fault. How dare they give us 50,000 hours of footage? Absolute absurdity. And again, now I'm labeled an anti-Blake content creator because I'm being rational and proving out facts. Spitting out facts, and it's, anti-Blake.
Within minutes of the judge's order, Twitter erupted into chaos. Screenshots of the sealing notice spread across timelines, often paired with bold captions speculating about what Blake Lively might be hiding. Gossip outlets didn't wait for official confirmation. By the time the court statement was released, hashtags like #SealedForBlake were already trending worldwide. Journalists weighed in with long threads, blending legal procedure with thinly veiled guesses about the testimony's contents. Supporters framed the ruling as overdue protection for a celebrity who had spent years under relentless media scrutiny. Critics saw something more troubling, a precedent where the wealthy and powerful could conceal evidence the public had a right to know. That clash unfolded in real time, fueling posts that pulled tens of thousands of likes and retweets. One viral tweet cut through the noise with just 7 words, "If it's harmless, why seal it?" Posted alongside a glossy photo of Blake and her husband on the red carpet. Over on Instagram, a meme featuring a locked briefcase labeled The Blake Files racked up shares in the tens of thousands. Soon, fake screenshots claiming to be leaked testimony circulated widely, obviously fabricated, but convincing enough to spread into forums and fan communities, where they were debated as if they were authentic documents. Hashtags told the story of the frenzy, #what did Blake say, #depositiongate, and the sarcastic #protect the Queen dominated feeds. On Reddit, sprawling threads surfaced with unverified first-hand accounts from supposed courtroom spectators, timelines pieced together by anonymous posters, and speculation disguised as fact. Verification mattered less than speed. In the social media arena, the first version of a story always outpaced the truth. Mainstream outlets struck a more cautious tone, sticking to the dry details of the ruling. But on YouTube, live streams ran for hours, analyzing everything from Blake's courtroom posture to the length of pauses before the judge spoke. Every detail was treated like a clue in a mystery, and the gap between professional reporting and raw online speculation only fueled the sense that something much bigger was being hidden. Then came the celebrity reactions. An actress in Blake's inner circle posted a lock emoji to her Instagram story. A producer she once worked with tweeted a zipped mouth emoji with no context. Neither named Blake, but the timing was enough to send fans and blogs into overdrive. Ironically, the storm only gave Blake's camp more control. With nothing concrete to counter, they didn't need to issue denials or clarifications. Silence itself became strategy, and in the absence of answers, the only thing left for the public to scrutinize was the judge's startling decision to seal her words in the first place.
Actually mentioned in this from his own team, Justin's team, to notice that, yeah, they are doing this. Rather than actually get to the real subpoenas, they're still out there trying to find evidence, which doesn't exist. Clearly, I know it doesn't exist with me, doesn't exist with them. This period, especially in question, I don't know what they're thinking. There was no retaliation, it seems. Just because there was a text saying we can bury anyone doesn't prove they did. The internet reacts the way they do. That's what's so frustrating, why I've been so passionate about this. We reacted to Blake's own words, not to Justin Baldoni's PR campaign. It's offensive how dumb she thinks we all are. All people who reacted genuinely to what Blake did that summer. We're all part of a retaliation smear campaign. Give me a break.
On paper, the reasoning for sealing Blake Lively's deposition looked simple enough. The judge's written order was brief, stripped of flourish. It stated that releasing the transcript could cause undue harm, and that in this case, privacy outweighed the public's right to access. Clean. Direct. Final. At least, that's how it appeared at first glance, but the gaps were impossible to miss. Undue harm to whom? Blake herself. People named in her testimony. The broader case. That phrase could apply to anything from safeguarding minors, to shielding business records, to sparing someone from public humiliation. And the reference to privacy concerns raised even more questions. In the courtroom, privacy is an umbrella term so wide it can cover sensitive but irrelevant details, or act as a polite stand-in for what's inside isn't flattering. By avoiding specifics, the ruling invited more mystery than clarity. That vagueness wasn't accidental. Legal language is often razor-precise when necessary, and deliberately broad when it benefits the process or the players involved. In high-profile cases, silence can be its own strategy. When the record is sealed, speculation fills the vacuum. There's precedent for this. Judges have used almost identical wording in other celebrity disputes. An actor's deposition about private medical treatment was locked away under undue harm. A fashion mogul's correspondence with business partners vanished behind the catch-all of privacy concerns. Each time, the ambiguity fueled more theories than it silenced, with observers left piecing together fragments they could never confirm. Analysts believe the same dynamic is at play with Blake. Some argue the wording signals protection of third parties, individuals dragged into testimony who never consented to public exposure. Others suspect the judge was guarding against prejudicial publicity, where raw allegations or half-formed details hit headlines long before the court decides their relevance. Yet one detail is especially telling: the ruling made no mention of redactions. In many cases, courts will black out names or sensitive passages, then release the rest of the transcript. That compromise preserves transparency while still shielding private matters. Here, that option wasn't even raised. Which leaves two possibilities: either the sensitive information was so deeply woven into the testimony it couldn't be separated, or there was never any attempt to separate it in the first place, and that's where speculation takes over. A locked door doesn't kill curiosity, it heightens it. By keeping the explanation broad, the court didn't close the discussion, it poured gasoline on it. Now, debate is sharper than ever. Was this a genuine matter of legal necessity? Or the first layer of a larger cover-up to preserve a carefully maintained Hollywood image? Inside the courtroom, Blake may have walked away with a victory. But outside, the sealed deposition has left her both protected and under greater suspicion than ever. The law may have closed the file, but public imagination has flung it wide open. And every unanswered detail only sparks another theory until, in the absence of facts, every theory sounds possible.